Welcome, everybody. I hope everyone is staying safe and healthy. And I'm, delighted to be here. My name is Colin Swan. I'm a vice chair of the Debarment and Exclusions Subcommittee of the IBA's Anti-Corruption Committee. And today we'll be talking about the Global Exclusion Survey, which is one of the projects that the subcommittee has been working on. And so thank you all for tuning in to this webinar. This, I believe, is the first official event of the Debarment and Exclusions Subcommittee. We have an excellent panel of speakers, all of whom are our subcommittee officers. I'm just going to run through them very, very quickly. The bios are on the IBA website, so if you would like to learn more about any of us, please don't hesitate to go there. We are joined by Roland Stein and Juan Renderos, who are the co-chairs of the subcommittee. And then Simon Leliberte and Sope Williams-Elegbe are both vice chairs on the subcommittee. And you should be able to see all of us on our screen. We will try to save time for questions at the end. We only have an hour, so we're going to try to zoom through as much as possible. If you have a question, would like to have a topic to discuss, please use the chat. That is how we'll do our best to accommodate questions from any of you, and we'll try to keep this as orderly as we can. Before I launch into some of the substance, I want to give Juan and Roland a little bit of time to just introduce the subcommittee, explain kind of its origins, and sort of what the hopes are for the subcommittee going forward. So, Roland, do you want to take it over?
Yeah, sure. I think the idea that we had started a while back because exclusions and debarments they happen all over the world, and the message to companies is always the same. It's you're out of government business, and while this message can be pretty, it's pretty unique and touching on businesses. There are hundreds and thousands of different systems, and so the singular message is conveyed in various ways, and you have a huge number of differences with regard to the grounds for exclusion. So you have bribery, fraud, non-payment of taxes, and so forth. You have different types of exclusions. So you have mandatory exclusions on the one hand, you have discretionary exclusions on the others. It depends on the type of contracting authorities that are involved, or you have debarment authorities. You have different procedural issues, from the standard of proof through judicial measures. So you have a whole set of different rules that can apply. And the idea that we had is to really discuss all these similarities, but also the differences on the worldwide issue. And I think this is only the public procurement angle, and I'm sure that Juan will be happy to speak about introducing to the multilateral development bank angle of this matter.
Thank you, Roland. Juan, did you want to add anything?
Absolutely. Thank you very much. Very nice to be here with all of you, social distancing. I have to credit Pascal Dubois, who was the person at the IBA who actually pushed this subcommittee to exist. She was the first that brought us together and said it is important for the committee to form a subcommittee to address this issue. And of course, from the multilateral development banks, this is dear to our hearts because we, as part of our mandate of ensuring that the funds that have been entrusted to us, we have created the system to debar companies and to exclude them from participating in bank finance operations. And this, our system, is modeled after the U.S. system of debarment and exclusion that works at the federal level. Although we created our system a little bit different than the American system and we have our particularities, it so happens that everywhere else in the world there are systems that are similar to us. They work, some of them under administrative law, others work within criminal law. And what we want to do is, in this subcommittee, is try to bring everyone together that is somehow works in this area, either from the criminal side, from the administrative side, from the international side, and try to work together to understand how this is impacting not only corporations, as Roland was saying, but everyone, from the government point of view, from the international community point of view. That is sort of like the scope of what we're trying to do with this subcommittee. Back to you, Colin.
Great, thank you. That's a great overview. Yeah, and you know, one of the things that led to this subcommittee, that started actually a little bit before the subcommittee, was this Global Exclusion Survey, which was an initiative that began kind of on two different fronts. One was through, you know, the office that I work at, the World Bank's Office of Suspension and Debarment. You know, we had started a couple of years ago to conduct our own research into suspension and debarment and exclusion systems all around the world for many of the same reasons that Juan and Roland had discussed. You know, particularly Juan, who works at the Inter-American Development Bank. As international organizations, a lot of countries often look to these multilateral development banks for guidance or as models when improving their own exclusion systems or implementing their own. And so, you know, we thought it would make a lot of sense and actually be very beneficial to try to understand as much as possible about how exclusion is used worldwide across a whole range of jurisdictions. And so to that end, you know, my office started an initiative to conduct a survey, you know, to prepare this survey, to try to get a sense of what questions we need, and that ended up being in and of itself quite an undertaking, just simply thinking about what questions do we want to ask. And then at the same time, Simon, who works in the Montreal Inspector General's office, was having a similar thought, and so he approached the IBA with a very, very similar idea. Did you want to sort of speak about your motivations for getting involved, Simon?
Thanks. So yeah, of course, I mean, the survey that your office had elaborated was pretty comprehensive, and if some of the people who participated in that survey, in the pilot survey in 2018, can attest to themselves, they can see that, you know, it's pretty thorough. On our end, our office was created in 2014, so it's pretty recent, and we've seen from then there's a lot of questions that are arising in our practice, and we wanted to get a sense of best practices around the world, see if there's any areas that could be bettered in the way things were going forward. So yeah, and so when I went to the IBA, I met with Juan, who was there as well, and someone from the World Bank who then referred me to Colin to start the working group, which now has become the subcommittee. So pretty excited to start on this, and then to have this webinar, and then moving forward with the survey further on.
All right, yeah, and we had, as Simon had mentioned, with the survey, once we had developed these questions in collaboration with the IBA and Simon, Juan, Roland, and others, and Chope, we conducted a pilot in 2018 where we received responses from 11 different jurisdictions, and the main purpose of this pilot was just to test the survey, try to get a sense of what, you know, how the questions are being received, are people answering them correctly. We made some tweaks to that survey based on the responses and the results from the pilot, and that is what has brought us to this point, this next round of the survey, where we really are trying to expand the scope and the reach and the number of jurisdictions that are going to be covered by responses. So if anyone is interested, I will type it into the chat. But we have a write-up of the survey pilot results on the website, worldbank.org/exclusion survey, as well as a copy of the survey, the current version of the survey itself. So I would encourage anybody that has experience in exclusion or suspension or debarment matters in their jurisdiction or even another jurisdiction. We would be delighted to receive your feedback and benefit from your expertise. So that's what we're hoping to talk about here. So turning to the panelists, we've heard from almost everybody. I'm going to start with Chope here. I'd like to get a sense from each of you, just a quick update on the state of debarment and exclusion systems in each of your jurisdictions. And so you all of us come from different countries, different jurisdictions, some national, some international organizations. Chope is a professor at Stellenbosch University in South Africa, and she also has a wide-ranging expertise in debarment systems around Africa and elsewhere. So I will turn it over to you, Chope. What's going on in?
Thank you so much, Colin. Hi, everyone. So I'll talk about the two largest economies in Africa. I'll talk about South Africa and Nigeria. So for South Africa, it's sort of we're in exciting times in public procurement generally, because we have a new procurement bill which was released for public comment just a month ago. And if that draft bill has been in process for about 7 years, so we're hopeful that it will become law. And what it does is it actually makes significant changes to what used to be a discretionary, decentralized debarment system, and now contemplates the creation of a public procurement regulator who will become a centralized office for debarment decisions as well. And they also become mandatory. The other thing that has happened is that the grounds for debarment in South Africa have been significantly enlarged. So we have the usual fraud and corruption, but now also a little bit strangely refusing to sign a contract is going to be a ground for debarment, as well as issuing false invoices and convictions for professional misconduct, which were not in the old regime. And then it also, for the first time, also provides for temporary exclusion pending final debarment decisions. So it will be very interesting to see how this new framework works when, if the bill becomes law. In Nigeria, nothing has changed with the law, but the debarment system has become a little bit more active, and so there's now a public list of debarred contractors.
Okay, thank you, Chope. I'd like to turn next to Simon. You had mentioned a little bit that your office had been created in Montreal, and as a sub-national, sort of a local or regional government, what is your experience with state?
Colin, in Canada, it's kind of a patchwork framework for now. I mean, federal government has its own regulations, but then provincially, after a big construction scandal with corruption and bid rigging and all that, they created our office, but also regulations for debarment in 2012, which was a first step to exclude people who were convicted of certain offenses or people who did not rise to certain integrity levels. But then they also put in a second phase just a bit later, where it was you have to have an integrity certificate from the government for certain contracts for certain thresholds. And then, so basically now it's kind of a two-tiered system where it's not only if you are found guilty of certain things, you are debarred, but also to be able to bid on certain contracts, you have to have this integrity certificate. So generally, that's the system that was put in place. And apart from us in the municipal arena, also that has regulations municipally in Montreal where you could be debarred since 2016. And there's also communication between us and the provincial level regarding certain findings that we make in our investigations. But as any other event where there is a scandal, the further away you move from that scandal, the more people start to challenge the system itself, which is just normal because the decision makers become more and more efficient in what they do. They start to have effect in what they do. And so you're seeing a lot of court challenges, not only for the decisions themselves, but to the system as a whole. Basically, some people are trying to contest the fact that there's a huge economic impact for the companies themselves. If some are based on a lot of public contracts themselves being pushed out for 5 years, they're saying it, sometimes they're trying to say that it's a cruel and unjust punishment for companies, which has been kind of, there's a big debate around that for if it doesn't extend actually to companies themselves and not just to individuals. But you see a lot of contestations in court challenges coming forward, which is just normal. And then we'll have to see how the system itself adjusts regarding to how courts do actually see the system that was put in place a couple of years back.
Excellent. Thank you, Simon. I'd like to turn now to Roland, who is a public procurement attorney in Germany with the law firm BLOMSTEIN. And so what is going on? What's the sort of status in Germany?
Okay. So I'll start with the European Union. In recent years, we have not seen any, huge legislative changes. So the system is pretty much the same as of 2014, whereas we have one European framework that applies in all individual member states, and that's a system which is basically run through exclusions, so each contracting authority is required to assess the reliability and to exclude a bidder in case this bidder is considered not to be a reliable citizen. And then there are some rules that apply in this regard, so mandatory grounds for exclusion, discretionary grounds for exclusion. So this has remained unchanged since 2014. It's being implemented into the member states, which have some margin of discretion to implement that as they wish. What's happened recently is that the EU Commission itself is setting up a debarment database. So it's an own, so in addition to the member states systems, they have in their own database. It's still, when you look at the size, not comparable to the debarment systems that you have at the multilateral development banks or even at the national level. But it's a growing system. There is some transparency, which for the companies means that you have a risk of being excluded at national level, and in addition you have a risk of being excluded at the EU level. So I think that's the first interesting development. The other one is that we have some interesting case law from the European Court of Justice, and that deals with the question whether an antitrust breach can lead to exclusion or a debarment. The question that applies there is if you have a antitrust breach. So the general rule is that this serves as a discretionary ground for exclusion. So the contracting authority can put you out of the government business. Now, however, you can regain access to the government to the procedures if you go through a so-called self-cleaning process, meaning you get rid of the people that did the bad things, you have some organizational measures, you cooperate with the authorities. And the question is, how does the cooperation with the authorities work in the antitrust field? So in particular, are you required to share all the information on the cartel with the contracting authority? So that's an interesting development, and the courts are working there to try to figure out what needs to be done and what would be too burdensome on the cartel members. Then perhaps just very briefly on the German side. We also have here no major legislative issues, but there's also some, on the debarment side. So on the first time, we're going to have a debarment system working at the federal level. So it will be an IT-based system, which I think from the outset is pretty similar to what we see at the multilateral development banks in the US. With a major difference that it will not be made, public. So the information on who is listed in this debarment system is, shut, and it will only be known to the office itself. And even the contracting authorities will only have limited access to this database, meaning that they will know if the company is, added to this list or not. So a big difference with regard to transparency. And I think it's still a good step into the right, to the right direction. I think we definitely have a downside when it gets to transparency. One other major difference is that, there are some major breaches which are not covered. For example, we've been speaking about the antitrust, and, the most severe breaches of antitrust, they are penalized by the EU Commission. And conversely, the German database will not deal with EU Commission decisions, meaning that, if you have a really hardcore cartel, you're punished by the European Commission, but you will not be added to the German database. And if you have a less severe antitrust breach, which is penalized by the German Foreign Cartel Office, then you have an issue with the database. So I think there are some inconsistencies. But at least, it's a sign that it's going to be in the right decision. Yeah, I think so these are the major issues here in Europe.
Thank you, Roland. And when is this competition database supposed to come online? Is it already online, or?
No, it was expected now in 2020. But, as always, it's not that much of a legislative issue, but an IT issue. And, we all know, IT can be a nightmare. And so I think everything is being pushed back. And so it's 2021, perhaps 2022. And now with all this Corona stuff, who knows when people are going to be able to start working on programming the database properly. So it's going to take a while.
All right, thank you very much. Lastly, I'd like to turn to Juan, who is going to discuss, not just the Inter-American Development Bank, but also, international organizations more broadly. How exclusion is used by those organizations.
Thank you very much, Colin. I hope that people can hear me well now. The system at the multilateral development banks was created to exclude individuals and corporations that committed one of the prohibited practices, and we have harmonized some of those prohibited practices. In other banks, we have added some additional prohibited practices. So the prohibited practices that we have harmonized are corrupt practices, fraudulent practices, collusive practices, and coercive practices. Obstruction is something that some of the banks we have, others don't. And most recently, we at the IDB have adopted misappropriation of funds coming from projects that we finance. That misappropriation requires there to be either intention, like intentionally misappropriate funds, or it can be done by reckless disregard. And we haven't yet had any of those cases because that's something very new in our system. But the systems work in the Multilateral Development Bank in a way that we have signed a cross-department agreement by which if we debar a person or a corporation for more than a year, the other multilateral development banks will apply that debarment. So debarment for us is not just for corruption, it's for all these other grounds that sometimes can be related to a corrupt practice. What we don't do is we don't debar for performance, and that is one of the differences, you could say, with the American system and with other systems around the world. In relation to what Roland was saying, one of the things that we do debar for is collusion, which could be related to competition issues in other legislation, like in Europe. So the debarment system, what we do is usually the cross debarment works for debarment, meaning exclusion, direct exclusion. But more and more, our institutions are working towards imposing other type of sanctions, like conditionalities, including incorporating compliance programs for companies to try to better themselves and come back into the market and do what they're supposed to be doing in helping development, which is what ultimately we do at multilateral development banks.
Thank you, Juan. And everything that Juan mentioned is applicable to the World Bank as well. And I think one of the biggest differences between not just the MDB subject to the cross-debarment agreement, which is the World Bank and the regional banks, the Inter-American Development Bank, African Development Bank, Asian Development Bank, and the European Bank of Reconstruction and Development, but several other multilateral development banks as well, is exactly what Juan mentioned. Poor performance or negligent performance is not one of the grounds for which these MDBs will exclude or debar or sanction a contractor. That is, however, poor performance is a ground that is quite common across a lot of national jurisdictions, particularly in situations where exclusion is a part of or sort of viewed through the lens of public procurement. The idea being the government does not want to do business with risky contractors or wants to protect the public fisc. In the MDBs, sanctions and debarment largely developed through more of an anti-corruption lens, which is why one of the many reasons why the prohibited practices that serve as the basis under these systems are the common kind of offenses: corruption, collusion, fraud, coercion, those types of things. So thank you all. I want to turn to Roland, if I may, and then all of you as well. But one of the questions that I think is on everyone's mind here is, why is it important to learn more about different debarment systems? I mean, what can we learn? And similarly, why should people take the time to complete the survey? What are you hoping or expecting to see from the results?
Yeah, I think it makes a lot of sense because, the issue is that we know so little. I mean, there is I think, all of us here, I think we have a good knowledge of the system that we apply in our day-to-day life. But if you look at I don't know how many minutes we've talked, but it's, a huge amount of differences and that apply worldwide. And if you look at it, the substance is always the same. So one would think, why are there differences, right? It doesn't matter if you have a bribery issue in Africa or in the United States or in China or in Germany, right? So it's always the same matter, but still you have different accesses to get back into the government business. So that doesn't really make a lot of sense. So I think it's really sensible to have a common knowledge of, on the way to finding a harmonized system, to at least have a knowledge of where the similarities and the differences are. Yeah. I think that would be my first answer.
along the same lines as what
Thank you.
Roland
Simon,
said,
would you like to chime in
well,
next?
we see a lot of companies that are coming internationally from other countries that are still working here, but then for them to get integrity certificate here, sometimes you have to take into account convictions they might have had in other jurisdictions. So then again, you're still applying to see how in other jurisdictions they've been found guilty or problems they may have experienced in other countries. And so once you're starting to look at that, you want to see how, obviously you can equate something from another jurisdiction to your jurisdiction, if you should or not. And so there's many questions that are unresolved, but that are arising as we move on with this new regime for us. As we said, in our province, it's 2012, so it's still pretty recent. And so I think the survey in that regard is going to help us to see, understand better how in other countries things are moving on debarment-wise.
But for at present, the contractors that have been debarred haven't actually been debarred for offences, in terms of fraud and corruption and all that, but they've actually been debarred for not being able to comply with federal statutes, so statutes relating to tax or compliance with pensions, law, social insurance, and
Sure. For us, it's very important. I mean, we do it from a very self-serving purpose in Latin America, because that's where we work. Almost all countries have a debarment system or an exclusion system, and they all have all kind of different ways to go to get there, either criminal, administrative, civil, and for us to understand how it works, what are the grounds for that, and how are they doing it, especially because they are excluding or debarring some of the corporations and individuals that we have to work with as well, because many of those projects in our region are financed by us, and those contracts are government tender contracts. So for us, it's very important to understand the different systems and how they work.
Thank you. And I'll add just one point that just touches upon a lot of these same points that were raised. Is there's been a question or two about cross-debarment, and there's been some discussion about cross-debarment, and Juan mentioned the cross-debarment agreement across the various MDBs. But what we have also seen is that there is often voluntary cross-debarment in the sense of certain organizations or even certain countries will follow voluntarily the debarment list of another jurisdiction. And so we've seen this in a number of instances where a country, or for example, the Indian Export-Import Bank will not do business with an entity that is debarred by the World Bank. And so that doesn't mean that there's an agreement between the World Bank and the Indian Export-Import Bank, but because of the prominence of some of these debarment lists, I think it can be very, very important to understand, what it means for a name to be up on that list and why. And so, to the extent that there are divergences in the grounds, in the procedures, in the severity, that can sometimes be overlooked in that type of situation where all they see is a name that's up on the list and they're just gonna follow with that. So, thank you. I'm going to turn back to Chope. I think we've already, I think, addressed, that there is not a lot of consistency across different debarment systems. But I was wondering if you could shed a little more light on that, particularly in terms of the terms that are used. In my own research, I've seen a lot of different terms: blacklisting, suspension, exclusion, debarment, sanction.
And so essentially what's happening in Nigeria is companies have been debarred for not meeting actual the eligibility criteria, not actually for offences. So more activity, but not what we would expect. And then South Africa has this new law coming online, hopefully soon. Yeah, I hope you can hear me. So for me, I think what's important is for us to be able to understand different systems, to share best practices around the world, to kind of know what actually works in order to safeguard procurement systems without hampering the efficiency of the system and unduly prejudicing contractors or suppliers. So for me, it's like what really works, what's really going.
Okay, thank you. Does anybody else want to weigh in? Okay. Turning to Simon then, a question that I had sort of jumping off of Chopé's point is that, some systems, not every system, in fact, very, very few systems will specifically articulate the purposes for which they're used, but you can often sort of glean the purpose through how the system is structured, through the offenses that are serve as the grounds for exclusion or for debarment. So sort of through this, it seems like some systems can appear more punitive or anti-corruption focused, looking at deterring or punishing bad behavior, while others can appear more focused on risk mitigation, the concept of present responsibility, which is a term used in the United States' system. The idea that a contractor in the moment is not presently responsible is too great of a risk to do business with the government. And so, Simon, I'm wondering, curious, what, if any, effect does the purpose of an exclusion regime have on a system's design and implementation?
Well, yes. Well, I mean, the survey itself, I think, just going back to one of the stats we had, was out of 11 respondents, I think 8 were governed by administrative law, and 1 was criminal, and 1 was both. So it's there is a wide variety, but a majority of them are administrative law. I think the difference might be twofold, where there, as a bit Sophie said, there's all the procedural part of it, whereas if it's administrative, there's more variety in what's happening. We found through the survey that there's a lot of differences for, let's say, like notices. When is a notice given? Is it at the start of the investigation? In some cases, that's what happens. Sometimes there's multiple notices that are given along the way. But in all cases, we found that supplier at least had the opportunity to contest the charges itself, or the case itself, if you will. But then again, the notion of contesting the case is in of itself something that is quite varied and quite large. Does the supplier have the right to present witnesses? Is it an oral case or is it a written submission? What kind of form of review is there available? Is it internally in the organization itself? Is it a judicial review? In our case, that's what happens. There has to be a decision-making body makes the decision itself, and then you have to go judicially to see if it was a fair decision or not. And so that's the first part of if it's based in administrative law, there's a bit more variety than criminal law, where procedures itself are more established through time, since criminal law has been there for longer in that sense. But also you would see differences in the findings itself. Usually, and we found through the survey that if it's through criminal law, then it tends to be more mandatory, the debarment itself, whereas administrative law sometimes may afford a bit more flexibility or discretion to the decision maker, who then has the ability to take into account, let's say, has the supplier put in place some remedial measures, or can the decision maker enter into an agreement or a settlement with the supplier. Whereas if they put into effect some measures, then they will not be debarred or under certain conditions itself. And so there's much more flexibility in administrative law. It also tends to be more speedy, especially for us in Canada, than criminal law. And also sometimes you would see if there is a specific entity that's created for that purpose in debarment, there might be some cases that, criminal authorities won't take the time to investigate because it's, not worth their time and effort. So you see a lot of variety depending on the scope of the regime itself, if it's based in criminal law or if it's based more in administrative law. So, I mean, I think that's generally where you would see some differences through the survey what we've found out until now.
Out there that are good practices that other countries can adopt. So I think that for me is really, really key. Yeah, so pretty much the same. So there isn't consistency in the terminology that is used, but there isn't also consistency in the nature of systems, whether they're criminal or administrative, whether they are mandatory or discretionary, whether they're centralized or decentralized. So
yeah, I was going to chime in into what Sope was saying, and that is that not only that, but in many countries around the world, criminal liability, it's only predicated on natural people, natural persons, not on corporations. And the idea of dealing with corporations from a criminal point of view, it's very new in some countries, for instance, in Latin America, and it is complicated. And when you bring all the apparatus of the criminal system to deal with those type of situations, it can take years. Whereas if you have administrative procedures within agencies or agencies dedicated to this type of things can move more quickly and can respond to the speed of business, which is at the end of the day what's happening in procurement. It's business. It has to go on. It has to move quickly in a way.
Thanks, Juan. And while we're on you and on the topic of administrative, there's been a kind of an ongoing chat discussion about the concept of settlements. And so I wanted to chat a little bit about that and see, Juan, there was a question about sort of a thought that the IDB, doesn't really do settlements. I had mentioned in the chat that the World Bank does settlements quite frequently, and that, particularly in common law jurisdictions like the United States.
Absolutely. We do have settlements within the IDB. In fact, we have signed a couple of settlements recently, big ones. The difference with the World Bank, though, is that for us to get into a settlement, there's a number of requirements we need to have prior to getting into that. And one of them is that we are going to get additional information about what is happening within an agency or what is happening with other corporations in order for us to deal with fraud and corruption issues within our operations. So it's not only that we are going to expedite the process and it's going to be faster and quicker for everyone and we're going to save resources, but that we're going to get something else that is going to help us with our objective of development. that we're going to be able to extract some information that is going to help us to retrofit what's going on within the agencies that we're working on, or is going to help us to address issues with other corporations. So if there's no possibility of us getting that type of information out of a settlement, we cannot get into a settlement. But in fact, we have used it, and we have, as I said, there's one recently with Odebrecht.
Yeah, I think, in particular, when you look at the, large, scandals, or either from a corruption or insolvency issues, I think really trying to solve that on a case by case, so contracting authority by contracting authority or bank by bank basis, that's close to impossible because the matter is so big and you have so many issues, on a worldwide scale that really it's only sensible to do that via settlement, where you try to figure out, where is this company looking into, where is this going into, and only if you bind that in a settlement, you will achieve that this company will really be readmitted to be a reliable corporate citizen again. So I think I guess that's the where we should be going to in the next years.
Great, thank you. And I'll add too, from the World Bank's perspective. I know when the World Bank first started doing settlements, the first one was actually with Siemens, and I think in part because of that, but also just because of the nature of settlements, there is often a belief that settlements favor larger Western companies over the smaller local companies or even individuals, and I think what we've found, at least in our data, just looking strictly at the settlements that do get negotiated and agreed upon in the World Bank sanction system, is that the composition of settlements that the World Bank agrees to are actually quite comparable to the composition of sanctions cases that go through the formal adjudicative process, which I think we found surprising in a good way, in the sense that the World Bank is providing this opportunity to anyone or any respondent, and that it is a mechanism that is being taken advantage of by a decent proportion of smaller businesses and even individuals. Is it perfect? No, I'm sure there are differences and issues that need to be addressed, but that was an encouraging sign from some of our own internal data research. So I'd like to turn to Simon, because we had a question from Sandeep Verma, one of our participants from India, about the integrity certificate requirement in Canadian law. He was specifically looking to the sort of risk of being granted such a certificate, and then something going haywire just a few days later or after there's.
Well, thank you for the question, Sandeep Verma. Just to make sure though, it's only in Quebec provincial law, so it's not for the whole of the Canadian government or federal Canadian federal contracts. The process itself, I think, is very resource intensive and it's still developing, because they started with certain contracts and then they're moving the thresholds down. To their main objective at first was to have all public contracts to have this integrity certificate that was required. The word integrity certificate, I'm trying to find maybe a better translation because it's in French. It's not a certificate per se. It's not meant to be an overall stamp of approval of the company and of all it's doing. It's basically to say that we've done a background check. Maybe that may be somewhat it's like an extensive background check of the company itself, to see that generally the criteria is that it's a company in which the public can maintain a level of trust. So as I said, it's not really an overall stamp of approval, but there is, as you mentioned, the possibility that it might be revoked, and that's why the legislation in place allows for revoking or suspending of the certificate itself, and then the company, if it is revoked, will then be debarred. The reasons itself might appear from different kind of investigations. Our investigations may lead to that. Sometimes we might get whistleblowers will call us and then we make an investigation and see that a company that did have this certificate was acting as a front for another company or another person who was undergoing a trial or was convicted of corruption. We have such cases in the past. Of course, it might lead to maybe less public trust against the regime itself, but I think that people are aware that it's the certificate is for, I think, 3 or 4 years. So there are a lot of things may happen, and I think people are aware that it's not meant to be an overall approval of the company itself and a blank check for them. So until now, I think it's working out pretty fine in of itself. And yeah, I hope that answers the question. If not, just maybe write it up again, and then I'll try to see if there's more specific points.
Okay, great. Thank you. We have just under 10 minutes left, so I'd just like to remind all of the participants, if you have questions, please don't hesitate to write them in the chat. We'll do our best to address what we can in the next couple of minutes. In the meantime, I'd like to at least start with Roland, but ask a question about sort of harmonization and standardization. There has been over the years, we've seen efforts, a big effort to harmonize procurement rules and terms. More generally, as seen through the OECD maps, the methodology for assessing procurement systems, the World Trade Organization's agreement on government procurement, and the UNCITRAL model law on public procurement. Debarment systems seem to not really be included in that harmonization effort, and I'm wondering if we could see a similar effort in the future. Is it possible?
Okay, can you hear me? Because I think my camera froze, but I'll start speaking anyway. So I think it's definitely desirable and possible. If you look at that from in Europe, we have had a harmonization which took a long time before it happened, but now in the 2014 regulations, now we have a common grounds for exclusions. We have, the differentiation between mandatory grounds and discretionary grounds. We have a defined set of exceptions, being from a statute of limitations to force majeure issues, which, could, unhappily play a role now with the coronavirus. We have rules dealing with self-cleaning. So how are you admitted back to business, and while we have some differences, huge differences, including from member state to member state, there is a general framework, and I admittedly there are differences if you look at it from a penal perspective or from an administrative perspective, but I don't see why this harmonization trend that we have seen in Europe, why this couldn't play also a role on a wider scale internationally. We are speaking about an issue which has a great economic and political importance, for all stakeholders that are involved. So it's for the investigating authorities, for the contracting authorities, for the companies, their competitors, and at the end of the day, for all taxpayers' monies. So I think it's worth to think of ways to harmonize that and to, at the end of the day, to achieve as level playing field as possible on an international level. Yeah.
There's a lot of variance, and even in the kinds of offenses. I was saying earlier that South Africa has a new offense of refusing to sign a public contract. So if you're awarded a contract and then you don't want to go ahead, then that can lead to your debarment. I suppose for wasting government time and resources, perhaps. So there's no consistency in the terminology, but I don't think that is I don't think that's of great importance. I think that what's more important globally is that we're sort of more, maybe not harmonized, but at least there's more global consistency in terms of the procedures we use, so that whether you're bidding for a contract in the UK or in South Africa, you kind of know what to expect. And of course, global supply supply chain.
Great, thank you very much. We have just about 4 minutes left.
Well, of course, I mean, as has been said, harmonization itself might be good in certain respects, but sometimes might be harder to figure out, and depends on procedural fairness in and of itself. Even in our country, sometimes it depends between the decision maker itself. So trying to have across departments sometimes may lead to extraordinarily high consequences for something that might be isolated itself in nature. Sometimes we're seeing now that because in our debarment scheme, there's a lot of convictions that may lead to debarment itself for different kinds of things. And so just now recently we had a head of a huge company that was also a political party leader who tried to finance his political campaign for the leadership and couldn't reimburse it according to the law with donations from individuals, and so paid it himself, which under the statute might be an infraction and might lead, if it does lead to a conviction, then that company, which is a huge player in telecommunications, might be excluded from anything related to public contracts. And so if there is, big cross debarment or harmonization, sometimes it might lead to, one company for one specific thing being debarred everywhere, which, sometimes might harm itself, public interest of having, the efficiency of the scheme itself.
Thank you. Yeah, and I think another thing that I often think about when I'm thinking about harmonization or just sort of comparing different systems is exactly what Chope said. You have to take into account the local conditions. You can't transplant the highly sophisticated, highly discretionary system of the United States into another country. This system in the United States provides such power and discretion to a single individual, a single public official in each of the agencies, the suspending and debarring official, that can have a very potential risk for corruption in and of itself. And we do see certain countries that will use the debarment system to go after political opponents and things like that. So I think there is a need to sort of take into consideration some of the underlying conditions and situations. We have 2 minutes, 1 minute left actually. I'm going to leave it if any of our speakers has any last minute.
The majority of the companies we debar in the multilateral development banks are small and medium enterprises. They're local companies. And although Airbus and Odebrecht and Siemens, they're big cases, they're very far and in between. The majority of debarments, even at national level, happen with small local corporations or local companies. So creating harmonization across all these countries, or thinking about big corporations and big cases may not be the right answer.
All right, thank you. We are at the hour. Thank you all so much for participating. I definitely learned a lot. I hope you did too. Thank you very much to our speakers.